Welcome. All right, we are live, and hey, welcome to our little web chat here. We're talking about probate living trust and your property. This is a big issue. It's a really big issue when we're talking about real estate, and I think a lot of people don't give it a lot of credibility that it deserves, or a lot of oops, hang on, a lot of yeah, a lot of the attention that it deserves, just because. Whoever plans on dying, whoever plans on dying. And I'll tell you, for me, Jack, one of the reasons why this actually is one of those things that I said, you know what, let me let's do a little chat about this, because we actually recently, just last week, we had a very dear friend pass away, and fortunately, she had all of her things set up properly, and her husband was there to take care of everything. But I've been in so many cases, being that I have done a lot of probates in the past. It's sad. I don't want to see people do probates just because it gets eaten up by a lot of other things. And if we can help one person avoid that pain, then that's great. If not, they can't say they didn't know.
Yeah, the only person who wins with probate are the attorneys.
Oh yeah, and I know,
Sadly.
And you can't. It's just what you do.
Yeah.
It's just what you do. And if people don't take the right steps, then you can't blame the attorneys. That's for sure.
We definitely earn our money. There's a lot to do in these probates.
Yeah.
But it's definitely something I try to make all my clients avoid. If people have the foresight to come in and do the planning, it can just really streamline everything.
Right. Yeah, so again, it's just one of those things that, man, it's just it's tough for everybody to be involved in that. So a little bit of background here. That's a picture of me and my wife, and back when I was dyeing my hair gray. Yeah, that's what I was doing. And I've been doing real estate for 20 plus years, and been all in every type of property, every type of sale, every situation. Divorces, short sales, foreclosures, pre-foreclosures, REOs, probate, trust sales, court-ordered sales. Those are interesting. Had a couple of court-ordered sales from people who were involved in criminal activity. So whole other story. But that's that's kind of me. And then I know Jack. We've been part of the same networking group and whatnot for a while, and got to know Jack a little bit. And there's a saying, Jack, and correct me if I'm wrong, but it says it's good to know your attorney. It's good to know your attorney. Or no, it's good to know who your attorney is, but not to get to know your attorney. Because if you get to know your attorney, you're paying a lot of money, right? Usually, that's the case. But I've had the great pleasure of getting to know my attorney friend Jack, and I think, in my assessment, there's a lot of background, skill, knowledge, and support also in what you do. So, give us a little bit of your background.
Yeah, no, absolutely. I went to Chapman Law for my law school. While I was there, I started doing a clinic class, which was called Elder Law. And that a clinic class is a class where you actually get to practice law, which was great for me. I really enjoyed it. You have a supervising attorney who guides you through it. And I really got into doing conservatorships and all this probate type of law and getting into it. So then when I had graduated law school, I moved on to working with my father, who had a firm. He had Kinley and Styskal lawyers that he started with my mother's uncle. And now it's my father, my sister, and I who are the attorneys here. And it's been great. I've got the expertise of my father, who's been doing this for about 40 years. And then I've got my youth and my sister's youth in order to make my clients, who I'm putting their estates together, know that we'll be around.
Yeah. So you got your father's experience and your guys' energy.
Yeah, youth and vigor.
Right, exactly. So, okay, hey, real quick before we continue here, let's check out this disclaimer here real quick. Every single situation has its own unique scenarios and should be handled appropriate to those situations. Me and Jack were just having a conversation. It's not intended to be legal, tax, or other professional advice. It's just a casual conversation that you get to listen in on. and maybe get some food for thought. You guys do not take any action without proper representation from the respective individual in that field. And if you do use this information discussed here, and you don't get proper representation, hey, don't blame us, because we will not be held responsible for your actions. There, we did that part. We always have to do that part, as silly as it sounds. It's kind of like those shows where you see people jumping off of bridges and stuff, and it says, "Don't try this at home." Really? Okay.
Yeah.
Yeah, but that's kind of the same thing. So let's talk about the living trust here, and the 3 years prior to Medi-Cal. Well, let's just talk about the living trust in general. First of all,
Absolutely.
how hard is it to get a living trust?
It's actually very easy. The hardest part for people is getting themselves to sit down and really take stock of what they own. That's the hardest part. And, making the decisions of where you want everything to go. Once you've figured that all out, the rest is very simple. You can contact an attorney like myself. I personally have a questionnaire that I have you just go through, fill out the blanks. Once I have all the info, it takes me about 48 hours to get your trust put in order.
Okay.
It's easier than people think.
Yeah, because I think in most situations it's probably it's probably standard for most people, because most people, they own one house, and maybe they have a couple of cars, and they have some bank accounts, and maybe some investment accounts. That's about it. And that's probably majority. So I would assume that'd be pretty simple. But in a case where it's getting complicated, I mean, that's what if I've got 15 different properties, and I've got multiple investment accounts and all this stuff? It's kind of the same process, or
it actually is. It's not. The complexity comes more in how you want it to distribute, and when you're trying to play tricks on keeping debtors from attaching to your trust, and doing lifetime distributions, and passing, do this person for life and then pass to that person, and then this interest. When you get more complicated in the distribution, if you have a complicated estate but you want it to just say go to your children,
right,
that's just as simple as if you had one piece of property. We just have more deeds to execute. But, the complexity comes in what you want the trust to do. If you're just trying to preserve your estate and have it distribute at your death, that's a very simple trust and can be put together just as simply if you have 1 or 15 properties.
So, okay, so then what would be some of the other reasons you would have a trust then, if other than preserving your estate?
The main reason is to avoid probate. I mean, if you have real property, you should have a trust. Because in California probate law, if you have over $150,000, or if you have a piece of real property that's over $50,000, you have to go through probate. Now, if it's under $150,000 and you have a $50,000 real property, you can do what's called a summary proceeding. But it's still not as beautiful as if you had a trust and had everything just wrapped up in a nice bow. If you have a trust, there's really no waiting. Once the person passes, your trustee can start administering and distributing right away. You don't have to check with the court about anything. The only time the court would become involved in a trust is if the beneficiaries are fighting or there's a dispute over the authenticity of the trust. But other than that, it just flows freely.
And how often is there a dispute in a trust in comparison to probably a probate? You have a will. I hear, of course, you see all the fun movies that, the family's fighting over the will. But in a trust, comparatively speaking, how often is there a dispute?
I don't see it that often. Most trusts will contain a clause that states if a beneficiary is contesting their gift, they lose their gift entirely. So that kind of deters people from contesting. Now, that kind of clause, if there is illegal activities that have occurred, if you contest and it's found to have been truthfully illegal, you're not going to lose your interest. But that means it's going to be a different document that's going to govern a different process. The trust will just be invalidated. So, people have to pick their battles wisely because you could lose everything if you're just being picky.
Right, right. And yeah, and I've got 100 sad stories about people who have let their property go into probate, and just even during the process of going through probate, uh, the property and the assets are just decimated,
Oh,
whether
absolutely.
malicious, well, definitely maliciously, by people who just don't think they got their fair share, and they didn't get named properly in the will or something like that. So, yeah,
It
trust definitely solves that problem, I think.
Probate just can really become a big mess. Anytime you have people butting heads, that's a huge cost because now you have to have trial, and you're looking at, like 20, $20,000 to $40,000 in about 2 years of trial work, just because you
Right,
got to ask questions, respond to those questions, find witnesses, find evidence, confirm everything. I mean, the attorneys are really working, and when you think about it, it's not 20 to 40,000 one person. That's two people who have to pay 20 to
right.
40,000. So
So I as a beneficiary, sadly my loved one passes away, and I'm sitting there thinking, okay, well, I mean, I'm sad they're gone, but there's a potential windfall coming my way, and then somebody wants to dispute it. Well, that whole windfall could just be just wiped out completely, depending on its overall value. And okay,
absolutely. And something to note is that when you're in a probate type of situation, the attorney's fees of the prevailing party are taken from the estate.
mm,
So your deceased family member's estate would be distributed to the attorney in part.
right,
So,
right.
yeah.
And so then, and I had a situation now, I don't know, 6, 8 months ago, where the family did not have, or the equity in the property did not cover the attorney's fees in this probate.
Yeah,
And
so there's
so,
nothing left.
well, there's nothing left, but now the family members are still stuck with attorney's fees. Is that not right?
Yeah, it would all depend on what the retainer agreement was for that attorney. The statutory fees, the law, what it states is that the attorney gets their fees from the estate, or they would have to be paid out of the party who hired them's personal account.
Mm-hmm.
Um,
Mm-hmm.
of course, the attorney has to wait till the end of the probate to get paid from the estate. If you do that, and you don't have an attorney's fees agreement that provides for the attorney to come after the client if it's not satisfied by the estate, that is a possibility. So
Mm-hmm.
if you are going through a probate, I would recommend that you have their fees contained to the estate if that's the route you're
Yeah.
going.
Well, I think that
Because,
the attorney probably knew that there was no equity in the property,
oh yeah,
and so yeah,
you know
so the
pretty
individual was
quickly if
responsible.
there's the money there as the
Yeah.
attorney because you have to declare to the court what is in the estate. So
Sure, sure. So that's a possibility for sure. But now, so what are some of the other benefits of living trust? And I mean, like for example, I mean, I have two, uh, preteen kids, and if I did not have a trust, um, and me and my wife passed away for some reason, what happens?
but that's a very complicated situation, to be honest. If you have children under the age of 18, what has to happen is a guardian needs to be appointed for them. If you have, they would inherit your assets, but they wouldn't have access to them until they're 18. So that guardian would be put in charge of managing those funds. It's called a guardianship. It's like a conservatorship where a party would be put in charge of your children. They'd be put in charge of your money to help maintain your children's lifestyle and what they need and take care of that. So then that person needs to be every year doing an accounting, reporting to the court saying, oh, this is what I've spent, which again is a huge depletion of your funds. You've
Mhm.
got a conservatorship or guardianship case costs, I usually make about $15,000 a year off of those. And
Mm.
so that's, this guardian's going to have an attorney.
Mhm.
They don't
Mhm.
technically have to, but they're going to be fumbling around trying to figure out how to do the proper reporting, and they're going to constantly have to keep going into court if they don't have one.
Yeah, and they have a responsibility to make sure that they're reporting correctly and using the funds wisely and correctly for their.
Oh yeah, the court monitors it to the penny.
And I'm sure this has never ever happened in a non-trust situation, but the kids never end up with the evil witch aunt, right? I think they do.
The courts do their best. I think the court system we have is the best we can make it.
Yeah.
Based on the amount of funding the courts have and the system that we've created to try to be equally fair on all sides.
Right.
But there are people who slip through the cracks. The court does their best to screen and have investigators interview people who are going to be put in charge of money and children. But there are some people who have their price. The court has some really amazing people who work for them, and there are some not so amazing people who do allow some fraudulent behavior to slip by. So.
Well, and I'm not even referring to fraudulent behavior, but I know, for example, there's probably people in on one side of my family that, it would just destroy me to find out that my kids ended up with them versus the people that I know would take good care of them and love them and help raise them appropriately. And so then that becomes a battle too. It depends on how much everybody wants to fight, because then, like for example, my mother, I'm sure she would go in there tooth and nail, but depending on her resources as well, So
right, the court, it's tough if you want. The biggest concern is if you want your children to go to, say, friends, not family. Mm-hmm. That's not necessarily going to happen when you don't have some sort of document stating your wishes. Because the court's going to want to put your children with family first. And although your children's wishes are going to be taken into consideration, they're going to try to figure out what you would have wanted. They're going to try to find the best family member to put them with. Right. So even if there's a neighbor or a friend that you really want them to be with, if you haven't told anyone that, and there's not a written declaration of that, the court's going to go through your family tree before they even think about looking at these other people.
All right. So I'll bring I bring this up because the trust is, like you said earlier, the whole purpose of a trust is to avoid probate. Well, there's a lot more to probate than just the property in that sense. You've got kids who are like you said, ideally they go to the right family member, they go to somebody who's going to love them and take care of them. But there's always a possibility that they end up with someone that you don't want them to be with. And so the simple answer, Jack, is
get a trust.
Get a trust, right? Of course. Yeah, that's the simplest solution. So,
you look at the amount of money it costs to do anything in the time. Keep in mind, a probate standard is going to be 6 months. Without even hearing the details of an estate, it's going to be 6 months because of all the notice you have to give. And that means that your beneficiaries are sitting there waiting, wondering for 6 months, and having to deal with the courts that whole time. And me. I have to keep pestering you. Hey.
So once somebody passes away and the probate process begins, in a sense, there's still somebody who gets assigned as an administrator of the property initially, because somebody has to be responsible and take care of the property. Right? Okay.
Yeah.
And how is that determined?
It's first person who asks, pretty much.
Really? Wow.
The first person who asks to be in the probate gives proper notice, and nobody is saying, hey, I don't want that person. They're going to get it.
Okay. So that's interesting because, and that goes back to another situation that we had where very, very loving, caring daughter, her father passed away, and he actually, his intention all along was to have her administer his estate and get everything distributed. Well, of course, we'll just call it what it is, the evil stepmother, who was no longer married to him, was actually divorced from him for a couple of years, had managed to get herself in a position where she was now taking care of everything and responsible. In the end, what ended up happening was the car that he had was nowhere to be found. She sold it. The safe that he had was nowhere to be found. A lot of the assets, a lot of the things that were in the house were just gone when the daughter finally was able to be allowed to go look at this. And obviously, she was just a bad person, and she did not follow. She did not follow the rules of the fact that she has to take care of and be responsible for the safety and security of the property, until the probate is completed. And I bet you that happens all the time. Somebody gets there and they start digging through grandma's drawers and they find all that gold jewelry. Gee, I don't know what happened to it. It just happens, right?
And that's kind of the beauty of a trust as well, because your trust states everything you have. So when you don't have a document stating everything, if somebody comes across, oh, here, look at this gold watch, well, no one knows it exists, so no one will be looking for it, and it's gone. And even if somebody does know it exists, you think about it, if somebody is stealing from the estate, they mismanage their power, well, now you've got to spend your time and money to sue them. And that's going to be, at least a couple of years for a lawsuit. You're looking at the $20,000 to $40,000 having to go to court. And at that point, it's like, what's your time and money worth? Is that gold watch really worth, the $20,000 to $40,000 in 2 years? And it's almost worth it to some clients to just walk away and let these people get away with it, because although the law is written to protect from that, actually implementing that law is very expensive and time-consuming.
Right. Yeah. Yeah. And that's why probate is just not the right way to go. It's just not the right way to go.
Yeah.
Hey, let's talk about real quick something that I knew of. I keep getting reminded of it because as I get into these cases or these properties that need to be sold, and we're in the middle of selling the property, the family is expecting, and now they've gone through the probate process, and they've been given the letters to sell the house and everything, but then they go through the process, and then suddenly, out of the equity, gets sucked out a bunch of money for medical expenses. Like what is it, Medi-Cal? If you have Medi-Cal here in California, then they're on top of it. They know that house is being sold, and that was the decedent's house, and that was the person who was on Medi-Cal, and now they've had $300,000 worth of medical services performed over their, the time that they were on the Medi-Cal, and that gets taken from the property.
Absolutely.
Yeah, I mean, can you shed some light on that?
Well, what happens is why the probate process is so long is you have to give notice. You have to publish in newspapers what's going on. So that's how they find out, And if you are receiving medical benefits, you specifically, by the probate code, have to notify Medi-Cal, Social Security. You have to tell all of them that you are doing a probate and there's going to be a liquidation. So they're on alert, and Medi-Cal they want to be reimbursed for their money. If your estate now has money, they want their money back. But I'm sure where we're going with this is that if you have a trust and it's put together properly and with enough time, that would remove that property from the estate, and you wouldn't have to go through probate. It's technically not belonging to the decedent. So when Medi-Cal wants to get their money back, they're just looking at what the decedent owns. They don't own the stuff in the trust is owned by the trust, not the person. So that's the distinction you're trying to make here. It's kind of like creating a company. You put it over there, and then you give all your stuff to that company, and you're the president of the company, so you can manage and work and play with it all. However, it's not yours technically.
Right, right. Yeah, and that's exactly where I'm going. Is that if you, boy, I mean, you'd be surprised. What do you mean? I thought Medi-Cal was free. I thought all that stuff was free. we didn't have to pay any of that back. That's like, well, guess what? Surprise, surprise. Now, my understanding, though, is that you have to have established a trust and had the property put into the trust 3 years prior to ever receiving any Medi-Cal benefits.
Absolutely. They're going to do it. It's called 3-year look back. And when you're actually applying for Medi-Cal, they will invest. They request your bank records. You know, they look 3 years back before even approving you. So if you don't get approved at that stage, then you have to wait maybe another year or some months, and then once it's 3 years away from your trust being created, then you'll be qualified. However, you won't have medical benefits for that period. You know, they want you to use your money. They don't want to take care of people who can take care of themselves.
Well, and the whole point of knowing this and understanding this is that, you know, you're in a situation now where, you know, you're in your 30s, 40s, 50s or whatever, and you're not in need of using those services. Boy, make sure you have a trust in place first, even if it's just maybe you don't even own property yet, but have your trust in place, and so that when you do buy property, it gets into that trust before you end up having to be on a situation where, you know, maybe you're retired or you become disabled or something like that. Now you're drawing on you know, state benefits. I don't know if federal benefits apply to the same rule, but you know, get that trust in there and just avoid that whole mess. So now, if I had, let's say, for example, I had at one point in time in the past had Medi-Cal benefits. I mean, you know, maybe a long time ago, for whatever reason, and then get back to work and making lots of money and doing all the good stuff, and everything's fine, and I create a trust. I buy properties. I put the property in the trust, and then, you know, and it's been 10 years, and then maybe I have to retire now, and now I need Medi-Cal or whatever to have medical. Does that property that was put in the trust during the period that I wasn't using, is that still affected by the original Medi-Cal usage?
Well, it's my understanding that when you originally got Medi-Cal, you were under a certain amount of money that you were making that you had for your daily living. Once your amount of, you know, so you have it, you don't need it anymore. Your medical condition's cured. But once you start making money beyond that limit, they're going to start contacting you if there is a record, which usually your taxes will tip them off on that. They'll contact you once you start making more money and say, hey, looks like you can pay us back. And then so that, if you're making good money, they likely will have already collected from you on that original. But let's say they didn't. If they didn't, and they just didn't know you were making more money, and then you make your trust, and then you start, you know, moving forward, that could be complicated. Your Medicare after 3 years of making that trust will not attach to it. However, they might claim that the previous Medicare before the trust could attach to it because you possessed that property after the time that you received the benefits and it was yours, and then you got rid of it.
Yeah.
It would be a sticky situation. You would argue, oh, well, I don't own it anymore, so, you know, you can't get it from me now, which you might succeed at, but it's going to be litigation. You're going to have to fight it and prove to the court that that's the truth.
Right, right. Yeah, that's and I've kind of heard a bunch of different, you know, scenarios on that where it just, you know, if you ever had Medi-Cal from that point forward, any properties attached to it, if it wasn't in a trust prior to that and all that stuff, or if you, I guess the only way to get around that is if you had that trust prior to that, you had Medi-Cal and then you bought a property, it would have to go straight into the trust, or I don't know, you know, I mean, and again, just, you know, to call Jack and work those details out if that's your situation.
That brings up a good point. A lot of people say to me, you know, I'll have clients, oh, I'm interested in a trust, but we're going to buy a property, so I'll wait till we do that, and then we'll do the trust. And it's like, well, yeah, I don't recommend that because now you're just paying for two deeds. Really, I mean, if we get the trust in order, you don't have to put it in your name. You can buy the property as the trust, and it's boom, instantly the first deed you get, it's now in your trust. Technically, technically you should notify your attorney after that so you can make a note of it in the trust, but if your deed has the property listed as part of the trust, it's in the trust.
Right, right. Yeah. Yeah, so I think the point, again, we just keep going back to the point is not, don't mess around and don't sit around and wait to do something like that, because especially when it's associated with a property, it's one thing when you have, a savings account, maybe you even got $50,000, $100,000. Okay, people got to fight it out. They're going to lose half the money to attorney's fees, not just attorney's fees, but court fees and all the other things that are associated with the probate. You still get some money in the end, okay, whatever. But we're talking real estate is, the biggest investment anybody ever makes in their life.
Absolutely.
Mostly. And you just can't mess around with that. And again, when you're dealing with your kids and stuff like that, don't mess with that either. I actually just learned recently of a thing called Proposition 58, and we just had a chance to discuss that for about a second before we started here. What's your take on that and keeping a tax base on a property after a death?
Well, that's exactly what it is. It permits for parents to, a parent to child passing a property to keep the original tax basis that the house was originally assessed at. So if your parents bought their house back in the 60s and now it's 2014, it's significantly increased, and I'd say it's probably increased by like $200,000 to $300,000 in the value. But when you inherit that property, you get to keep that 1960s tax assessment. You're going to just be taxed on what the value was at that time because the actual gain hasn't been realized yet. It hasn't been transferred to a new third outside party. But this only applies for parents to children.
Okay, parents to children. So does that apply in probate and in a trust?
Yeah, it does. Yeah.
Okay, so and that's important to know because you say $200,000 or $300,000. I know that for example, my mother-in-law, her house, she did buy it in the 60s. By the way, it's been paid off free and clear, and it is way significantly more than $200,000 or $300,000 in equity. But her taxes are, I think last time I talked to her about it, she said she's still only paying $1,200 a year in taxes, and which is nothing. But if we took the actual value of the house, at the time of her passing, if we inherit the property and now we've got to pay those taxes based on the current value, man, we're paying, $13,000 to $15,000 a year. Huge difference.
This proposition really seems to want to encourage lineal holding of a property. They want the parents to stay and then the children to stay and then their children to stay because, by the implications of this proposition, if you inherit to your mother's house and then you pass it on to your children, they could still be paying on the assessment of the 1960s price because then it's parent to child, no reassessment again.
Right, yeah, and I like that. I appreciate that.
Yeah, that's great.
it, like you said, it does encourage the keeping the property in the family. There's good things that come along with that. It helps build and transfer wealth as they move on. Just hope they're responsible enough to do that.
Absolutely.
Hey, let's talk about real quick about the expense of probate. And now, keep in mind, as a realtor, boy, I get hammered all the time on fees. Oh, you charge too much for what you do, because people don't realize the work that goes into it from a professional realtor's perspective. Because I don't ever mind saying this. I say it like it is. I just tell it the way I think is that there's a lot of agents. They probably don't need to be in this business, and they're amateur and they are. They're not career individuals. This is my career. This is what I do. But I get hit on fees all the time. But attorneys, you guys, everybody says, oh, you guys get paid too much too. for what you do. Gee, you only went to school for, what, 150 years or something like that, right? To do what you do. So, but let's give the breakdown of the fees associated with a probate to help people understand. Man, it's great for your pocketbook, Jack, but it's a waste of the estate's money to have to do that when they can do something as simple as a trust.
Oh, absolutely. I've had people call me, oh, how much is your trust? I charge, $1,500 for a couple, $1,000 for an individual. Well, how much is your will? Oh, I guess I could put together a will for $300. Oh, I'll do the will. It's like, well, hold on. You pay $1,500 and you avoid in a probate. I get, by law, it's written in the law how much I get paid. I get 4% of the first 100,000, 3% of the next 100,000, 2% of the next 800,000, and 1% of every 100,000 after that. So if you own a home, which in California is at least about $500,000 on average, I'm getting seven. You're looking at least like $10,000 to $15,000.
Right.
And that's just my fees. Then you have to pay $450 to file the petition. You have to pay $300 for the probate referee to assess the value of the estate. You have to pay $495 to publicize the probate. You have to then pay the bond, which is going to be varying upon how much the estate is, but it's usually about $200 that you're paying. And then when you're all done, you have to pay another $450 to file the petition to close the probate.
Wow.
Yeah, that's just the court fees.
Yeah. Oh my gosh. Yeah, that's pretty intense. It really starts to add up a lot. And
absolutely. Not to mention, then you need certified copies of letters that are $25 a piece. You need certified copies of the death certificates. You need to hire notaries. I'm a notary, so I always notarize all my client stuff for free. But those fees they collect and add up.
Right, and there's some people that are like, hey, well, I don't care. I'm going to be dead.
Yeah.
What do I need it? But it's the same thing about why do you have insurance? Why do you have insurance?
Right.
It's because you don't want your family members burdened with the expense of those things. Same thing with having a trust. A trust is just like that. It's like I wouldn't call it insurance, but in that same respect, it could be looked at that way. You're not dumping the burden of the expense on your loved ones. So I think that's
absolutely. And it's not just a monetary expense; it's a time expense, and that really wears on people. I constantly have people, "Hey Jack, what's going on?" It's like, we're still waiting. We got to because you petition for the power to be in charge. Once you have that power, you have to wait 4 months to just wait for people to pop up out of the woodwork, and before you can close it up and distribute.
Mm-hmm.
So you got people who really want that money, and a lot of people who really need the money. But we have to wait, and I say 6 months for a probate because, I file the paperwork. That doesn't mean I get to go to a hearing the next day. Our courts are so bogged down, they're setting court dates about 2 to 3 months away from when I actually file the paperwork. Mm-hmm. So then you add the 4 months of waiting on top of that, plus then after I have to actually wait the 4 months before I can file my final petition. And again, that could be another 2 to 3 months out for the actual hearing date.
Right.
So, I mean, 6 months is a very kind estimate. It's more about, I'd say, 8 to 9 months that you're waiting.
Wow. Yeah, that's tough. That's tough. Like I said, especially when those people who they need the money, they need to have that. But I would encourage people, if you're watching this, and you're in a situation where somebody has just passed away and you're expecting an inheritance and all that, don't get in the mindset of, oh gosh, I'm going to get this great big pile of cash tomorrow. Let it do its process and be actively involved of what's going on. Again, seen too many situations in a probate situation, not so much trust, but in a probate situation where things of the estate is just completely destroyed financially before it can get through the process, and then, like Jack said, then if you have to go back and fight that person in a legal battle to say that they didn't do their job. And even if you win, they have to repay the loss that you have to prove was lost. They probably already spent it.
Right, and yeah, that's exactly it. Is sure you may even win, and you are supposed to get your money back. People go, oh well, $20,000 to $40,000. Well, I'll get my money back. Yeah, the court may order them to pay your attorney's fees. That's about a 50-50 call. They don't always order them to pay your attorney's fees. But even if they do, a lot of these people who steal money, and I've seen it, spend it right away or give it to somebody, and it's like, okay, now you're trying to get blood from a stone. Is it really worth it? Or they skip town, go to another country.
Yeah, that's how I'm sure that's happened a lot. So, okay, well, you know what? Anything else that you want to add in here, Jack, about the probates, trusts, any of that good stuff that we should touch on before we wrap up here?
I just, I so emphasize trusts. I have structured my practice around making a trust as painless for my clients as I possibly can. I try to do a quick turnaround. Everybody wants to put it on the back burner, but you got to think of it. You got the probate system, which is going to cost you, I'll tell you, it'll be about, let's say, $20,000. And then you've got the time, 6 to 10 months. Whereas with a trust, you're looking at $2,000. And your estate can start being distributed once you die, because it's separate. It's just got separate guidelines that do its own thing. And once you've passed away, now those new procedures are immediately set into motion, and distributions can start being made once death certificates are in the hands of the trustee. So.
Yeah, I agree. I think that is. You need to just get that taken care of. And me as a parent, well, Jack, as you as a parent, especially if you have children, young children, and all that stuff right now, you just never know what today or what tomorrow is going to bring. So, if you have any questions, reach out and call Jack. Call Jack at Kinley Styskal Lawyers, and I'm sure he'll be happy to answer any of the questions that you have. And if you have any questions, if you got a property in the Orange County, Southern California area that you need to sell as a probate, by all means, give me a call. I'd love to sit down and talk to you about the way we do our sales, which is using the amazing open house technique. You can look that up. It's amazingopenhouse.com, where we basically get the home sold really, really, really fast and for top dollar every single time. So you don't have to be sitting there stuck with a property for months on end waiting for it to sell, like as is normal in the typical market. So, all right, Jack, last words?
Don't wait to do now what you'll regret later.
There you go. All right, guys, thank you very much for watching, and feel free to reach out to us. We'll catch you all soon.
Thank you, Anthony.